Welcome to the Weatherill Report, curated by Dallas Weatherill. Today, we're going to strip away the legal jargon and explain exactly what the Australian privacy law is, and more importantly, how it actually protects you and your family.
You know that feeling, right? You're faced with this giant wall of text, a privacy policy, and you just click agree to get on with it. We all do it. But have you ever stopped to think, what happens next? Where does all that information actually go? Well, it turns out you have way more power in that moment than you probably think.
All right, let's get right into it. The whole foundation of your protection comes down to something called the Privacy Act of 1988. And I know what you're thinking. 1988? But don't let that date fool you. It's been updated a ton over the years. It's really not some dusty old law book. A better way to think of it is as your digital safety net, and it's constantly being upgraded for our modern lives.
So at its heart, this act is kind of like a social contract, but for the digital age. It sets out the basic ground rules for how companies and other organizations are allowed to collect, use, and handle your personal info. It's all about creating a framework of trust, so we're not just throwing our data into the void. Here's a really simple way to think about it. Imagine your personal information, your name, your address, even just what you look at online, is like your set of house keys. I mean, you wouldn't just hand your keys over to a complete stranger, right? Not without knowing who they are and what they're going to do with them. Well, the Privacy Act is built on that exact same idea.
Okay, so let's break down the first big pillar of your protection. This is fundamental. It's your right to know. Simple as that. Before any company can even ask for your keys, so to speak, they have to tell you exactly what they're planning to do with them.
And let me be clear, this is absolutely non-negotiable. Companies can't just, secretly slurp up your data in the background. They are legally required to be open and totally transparent about what they're doing. This isn't just a friendly suggestion. It's a cornerstone of the law. And the law gets super specific on this. There are these things called the Australian Privacy Principles, or APPs for short. Under these rules, companies have to tell you exactly what data they're collecting and, just as important, why they're collecting it. They also have to fess up if they share it with anyone else and tell you how you can get a copy of the data they have on you. And this is a big one. With the latest reforms, they even have to tell you if an AI made a major decision about you. Think about something like a loan application.
But, knowing what's happening is really only half the battle. The law also gives you a direct say in how your keys get used. And this is where you really get to take back control.
Look, when you give a company your permission, it's not a blank check. They can't just take it and run. If you hand over your data for one specific reason, they can't just turn around and use it for something completely different without getting your okay first. You absolutely have the right to draw a line in the sand. The law actually makes a really important distinction here. Let's say you give a store your address for a delivery. Okay, that's what they call the primary purpose. But what if they then start using that same address to spam you with marketing mail you never asked for? Well, that's a secondary purpose. And for that, they almost always need to get your explicit consent.
So how do you actually use this right? Well, a few key things. First, their privacy policy has to spell all this out clearly. Second, for anything like direct marketing, they have to give you a super simple, obvious way to opt out. And third, and this is so important, your consent can't be buried in paragraph 57 of some vague terms and conditions. It has to be a specific, voluntary, and totally informed choice on your part.
All right, this next one is a biggie. It's one of the most powerful rights you have, and it's all about making sure your digital footprint doesn't follow you around forever.
Your data, believe it or not, actually has a shelf life. Companies aren't allowed to just hoard your information forever once they don't have a good reason to keep it anymore. They're legally obligated to either securely destroy it or de-identify it so it can't be traced back to you. Basically, you have the right to get your old keys back and make sure they're destroyed. And the latest reforms have made this even stronger, turning it into what's called a right to erasure. This goes way beyond just them having to keep your data safe. It gives you the proactive right to go knock on their digital door and say, hey, you don't need my info anymore, get rid of it. Okay, so it's one thing to have all these rights written down on paper, right? But it's a completely different thing to actually have them enforced. And that is why these recent updates are such a massive deal. The privacy law has just been given a serious upgrade with much, much sharper teeth. Get this, $50 million. That is the new maximum penalty for a serious privacy breach. And it's not even just a flat number. It can also be calculated as a percentage of a company's total revenue, which could end up being way, way higher.
This, right here, is why boardrooms all across Australia are finally sitting up and taking privacy very, very seriously.
And, you know, these changes aren't just happening in a vacuum. The Australian Privacy Commissioner, Carly Kind, said it herself. This is a direct response to what the public has been demanding. People are just plain tired of feeling like they have no control, and the government has finally stepped up with much stronger laws.
And this next part is a real game changer. It used to be that your main option was to complain to the regulator and hope for the best, but starting in mid-2025, there's a new legal tool called a statutory tort, which basically gives you a direct path to the courts. What does that mean for you? It means if a company seriously messes up and breaches your privacy, you can personally sue them for compensation. And we're not talking about some far-off future here. This is happening right now. The new laws were passed in late 2024. That right to sue? It kicks in mid-2025. And by the end of 2026, there will be a specific code just for protecting kids' privacy online. The ball is already rolling. So, what's the bottom line here? It's that the balance of power is finally shifting back to you. You have clear, undeniable rights, and the laws that back them up are stronger than they have ever been before.
And all this knowledge, it moves you from just being a passive user clicking agree to being an active, empowered digital citizen. So the next time you're asked for your keys, you'll know exactly what to ask and just how much control you really have. This has been the Weatherill Report, curated by Dallas Weatherill, turning complexity into clarity. We hope this makes you feel more in control of your digital life. Visit our website for more clear English guides.